I want to talk today about Padilla motions. Now, in 2010, in the case of Padilla versus Kentucky, the United States Supreme Court ruled that if a criminal defense attorney fails to explain to his client the immigration consequences of a criminal conviction or a plea, or fails to research the matter, then that could be considered ineffective assistance of counsel, and sometimes you can withdraw your plea and start the case over. And I'll give you an example. Suppose you're charged with possession for sale of methamphetamine. Now, there's no question that that is a conviction that will trigger immigration consequences. It will get a non-citizen deported from the United States and make him or her unable to become a citizen later on. Now, suppose the attorney says, look, it's fine. I got you a great deal. Just plead guilty. Don't worry about deportation. Nothing's going to happen. So you go ahead, you sign the forms, you plead guilty, and sure enough, a year later, you get picked up by ICE and put in removal proceedings, and now you're facing deportation. Well, that may be a situation where we can run a Padilla motion, and if successful, allow you to withdraw your guilty plea, negate the conviction, start the case over, and then work to resolve it in a way that's not going to cause you to be deported. Now, keep in mind that Padilla only applies to cases or convictions that occurred after March 2010. But even for cases before that date, there may be other avenues of post-conviction relief. So if you're in a situation where you're about to be deported, you've been convicted of a crime that triggered immigration consequences, we invite you to contact us. We may be able to make an effective Padilla motion or find some other avenue of post-conviction relief to ultimately keep you in the United States and resolve your case successfully.